Lawyers have read it. What was the best gotcha moment you ever experienced? Story 1. My client's house burned down due to an explosion in the fuel oil tank used to heat his house. It was clearly the oil maintenance company's fault, but his homeowner's insurance, from a very reputable company, still refused to pay out, citing a ridiculous technicality in his policy. Essentially, the policy covered damage caused by the oil heater, but they claimed that it was the storage tank that exploded and wasn't part of what was covered. So they denied his claim, which was about $1.2 million. Then I got involved. During a deposition with the claims adjuster, I asked how she came to the conclusion that the storage tank was not a part of, or at least connected to, the heater. She stated that she relied on her expert witness, who was an engineer. Little did she know I had already checked this person's background. He had zero engineering experience or education. As most of you might know, you don't get attorney's fees in most cases. However, when an insurance company denies your claim in bad faith, now you do. Her little admission cost the company about $500,000 in fees, on top of the original claim for $1.2 million. Story 2. I represented a DUI client who swore up and down that he hadn't been drinking or using any drugs. A newbie officer was with his field training officer in the car. The rookie pulled my client over for a tag violation and walked back to the car with his body camera still on. The training officer said, "Get him out for DUI." And the rookie replied, "But he's not intoxicated," to which the training officer responded, "Do it anyway." The body cam clicked off and then turned on 7 minutes later while they were doing field sobriety exercises on my client. My client sat in custody for 3 weeks until I finally got the tape from the prosecutor and presented it to the judge. The "oh no" looks like from the prosecutor and the FTO when the judge saw that the tape were priceless. The judge wrote a letter to the police chief stating that the FTO was dead to him and that he would deny every search warrant the FTO tried to bring thereafter for being a liar. My client is hopefully still on track with his civil attorney in a lawsuit. Story 3. My brother is an attorney. He had a case where a guy claimed he was permanently disabled from a work accident. During a deposition, my brother overheard the guy talking about getting his house remodeled. The guy was already spending the money he thought he was going to get. My brother drove by the house to see how much work was being done and saw the guy carrying bundles of roofing shingles up a ladder to the roof. That was before smartphones, so my brother drove to a Best Buy, bought a video camera, went back and recorded the guy. He had copies made and sent them to the other attorney. The guy dropped the suit and was back at work the following Monday. My brother's client didn't want to pay for the video camera. He saved them thousands of dollars. They eventually paid, but he still gets a little peeved when he talks about it. Story 4. I'm not a lawyer, but a legal videographer. A gentleman was claiming injuries and seeking damages against his employer after a fall at work. He claimed he couldn't raise his right arm above his shoulder because of the fall. During the first deposition, I was hired by the defendant's attorney to videotape the deposition of the plaintiff. Anyone know the first thing a court reporter asks you to do in a deposition? Please raise your right hand and repeat after me. The plaintiff raised his right arm above his shoulder with ease and no sign of discomfort, not realizing what he had just done. Both attorneys were looking down at their notes when this happened, and neither of them caught it. The plaintiff himself didn't catch it. The court reporter looked at him and then at me, and her eyes went wide with realization at what just happened. 4 hours of deposition followed, during which the plaintiff was instructed multiple times to show his range of motion, and he pretended he couldn't raise his arm above shoulder level, despite having done so at the very beginning of his deposition. The deposition ended, and plaintiff counsel left. I called the defense counsel, the hiring party, over and showed him the first 2 minutes of the tape. The counsel excitedly whispered to me, "Case closed. You just saved us tens of thousands of dollars." I got a $5,000 bonus, and the plaintiff's case was dismissed with prejudice. Story 5. My client was a woman working at a meatpacking plant. Her glove, they would only give her the loose kind because they were cheaper, got caught in a machine, and she lost her arm. We sued the owners of the plant for the glove issue. We also sued the machine manufacturer for failing to include the required guard. Then, we sued the distributor for being in the chain of the sale, but we didn't really think they played much of a role. The manufacturer swore they included a hand guard and said the plant owner must have used a grinder to take it off. During a deposition of the guy who owned the distribution company, he showed up with the sale documents that he was supposed to have turned over weeks before. It turned out there was a note in small print at the bottom that he didn't know about, stating the sale was without the hand guard, which is against the law. I pointed it out and we ended up settling that afternoon with the distributor. The woman got all her medical bills paid, got money for a prosthetic, and received a substantial amount for pain and suffering damages. Story 6. I was representing a mother in a bitter custody fight. The father wanted full custody and argued that the mother was an unfit parent. The mother wanted full custody because the father had a history of domestic violence toward her and the children. The father's lawyer was doing a good job of painting her in a bad light during the cross-examination, and I was starting to get worried. His lawyer brought a close family friend as a character witness for the father, who said that usual nice things about him. Then he mentioned something about them owning chickens. I thought that was odd, so I asked more questions. I was able to get the friend to spill the beans that the father owned chickens for illegal cockfighting. He'd take his minor children to these cockfights, and when the children were acting up, he'd punish them by forcing them to feed the chickens, during which they would get pecked and scratched by the chickens. The children were obviously terrified at the chickens. I could see the color draining from the father's lawyer's face. The mother got full custody. Story 7. When I was a prosecutor, I had a guy who was representing himself. He was charged with car theft and evading arrest. He had actually managed to escape the cops for quite a distance before being captured later. His defense was that he wasn't the person who committed the crime. I got his calls from jail, and he talked extensively to his girlfriend about how he had committed the crimes. The look on his face when I told him that I was providing him copies of the jail calls was priceless. I remember an even funnier thing. I had another guy who was representing himself. It was a residential burglary case, and one of the elderly neighbors saw the defendant running from the house. At trial, the defendant was cross-examining the witness and asked, "Now, when you saw this person running away," the witness interrupted and said, I saw you running away." Story 8. I served on a jury that was deciding a medical malpractice case. The plaintiff's common bile duct was cut during a gallbladder surgery, a risk that she was made aware of beforehand. She was suing the surgeon who performed the operation. The plaintiff's lawyer called a surgeon as a witness who had performed this surgery thousands of times. Speaking from his breadth of experience, he told us the mistake was entirely unacceptable and something that no competent surgeon would do. The defense lawyer got up and grilled him for a while, making it clear that this guy made bank by traveling around the country testifying against other surgeons. Right before he sat down, the defense lawyer asked, "By the way, have you ever cut the common bile duct during this surgery?" The case was decided, and the jury all but burst out laughing when he answered, "Yes, I have." Story 9. A husband and wife were charged with drug sales. The wife had given a full admission to the cops and ended up pleading guilty before trial. The drugs were found in a shed with tools that the husband admitted were his, but he denied knowing anything about the drugs. I went to trial against the husband, and during his testimony, he mentioned something about traditional family values. On cross-examination, I started asking about his relationship with his wife. He admitted that he was in charge of the finances and that she had to ask permission to spend money. He eventually said that she didn't do anything without his permission. I then asked him if he knew she admitted to selling drugs. He did. So wouldn't she need his permission to do that? Of course she would, he said. No further questions. The jury came back with a guilty verdict in less than half an hour. Story 10. My grandpa has told me this story at least 100 times, but it's always entertaining. He was the jury foreman for a murder trial in a small town in Tennessee. Two guys got in an argument at a bar with the victim. They drove home, got a rifle, came back, and shot the guy in the head. Months later, while on trial, the two guys were hammered by evidence and eyewitness testimony. They had left a huge trail of evidence. As the trial was about to wrap up, with them facing a murder conviction, the prosecutor brought in the final nail in the coffin. A surprise witness who happened to be the guy they had supposedly murdered. Those two idiots had shot and killed the wrong person, who happened to be in the wrong place at the wrong time, wearing the wrong clothes. Stupid. Story 11. Not my story, but my mentor's. He worked in personal injury and accidents. The accident involved two very expensive cars, his clients being new and the opposing sides being a vintage collectible. The case was only in regards to damages and what each side owed each other. The opposing side tried to claim paint damage on the front where there was a collision, asserting that the cost of the paint job was no longer made and had to be custom made, mixed and applied especially, making a big deal over the paint. My mentor had keen eyesight and pointed out that if the paint was damaged, where were the paint chips, as they were missing yet not on the ground or embedded in his client's obviously contrasting car. This was brought up in cross-examination and was met with a dumbfounded look and silence. This bore a huge hole in the credibility of the opposing counsel and eventually led the very expensive case going in his favor. Story 12. I represented an insurance company to recover monies it paid under a homeowner's policy. It was a multi-million-dollar home with a 450-gallon custom fish tank on the second floor. The owner hired a company to clean the tank, and they brought in a fish specialist to ensure the fish were properly maintained and stored for the cleaning. The specialist then went to lunch and turned the job over to a 22-year-old that he had hired a week before, who could have doubled for Keanu Reeves and, Bill and Ted's Excellent Adventure. The kid just had to drain the tank and start cleaning. Up until I deposed this kid, the fish tank company claimed they had properly drained the water into the municipal sewer system. This was not the case. The kid, who had been fired long before I deposed him and didn't care much about rolling on his employer, testified that he sparked a joint right after his boss left and then proceeded to drain the tank. But it was the first time he had done a second-story job. The hose they had wouldn't reach where it needed to go, so he went into the nearest bathroom. Mindful of his customer, he didn't want to dump 450 gallons of dirty fish water into the tub or sink, so he leaned the hose over the counter and into the toilet. He ended up walking out and leaving it there to grab some munchies. When he got back, there were 449 gallons of dirty fish water, all throughout the house. The case settled within 3 days of the deposition. Story 13. Not me, but my father, who also isn't a lawyer, was a representative from our state in a lawsuit against the Chrysler's automobile company. Being that my dad owned a Chrysler 300, he agreed to go to Detroit and answer questions from lawyers about the safety of the vehicle he drove. The car had a recall because you could shift the car into park, and the parking brake would not engage. It ended up killing someone from Star Trek in San Francisco because he was parked on a hill and got run over. While my dad was in Detroit, the Chrysler lawyers knew everything about him and ripped him apart. My dad's final straw was when he was asked, "Do you own a Chevrolet Impala?" And my dad replied that he did. The lawyers then asked, "Who drives that car?" My dad replied, "My son, which is me." They know that I was 16 at the time and that it was an old car, and went on to list about 15 recalls on my car that we had not fixed. To top it off, they said, "Do you care about your safety more than your son's?" To which my dad stated that he would like to come off the stand and be excused from court. He caught the next plane home and never received money from the lawsuit. Story 14. I'm not a lawyer, but in college mock trial, I played a bartender who had served the defendant the night they crashed their car, killing the passenger. The defendant's affidavit claimed they were gifted several shots of Everclear by the bartender right before they got into the car to leave. The bartender's statement, of course, didn't mention anything about that. So at a pretty important semifinals competition, opposing counsel was cross-examining me about it, and I calmly told them that wasn't true and couldn't be true because the bar didn't even stock Everclear. Opposing counsel clearly wasn't expecting me to say that, and I continued saying, "Yeah, we don't even have Everclear on our menu." Mock trial has 3 attorneys per side, and the other 2 attorneys began frantically flipping through their binders to find the bar menu, which was in evidence. It was extremely satisfying to see those 2 guys both realize simultaneously at the bench that Everclear was indeed not on the menu, and one of their most crucial lines of questioning was worthless. Story 15. I'm an in-house attorney for an oil and gas producer. We had been sued by a landowner who claimed that our operations on her land had drained a lake on her property. According to her, she had this gorgeous 6-acre lake on her land that was surrounded by trees, where she could swim and had wildlife around it. She alleged that we had done something to cause it to drain, reducing it to little more than a muddy bog. I attended the deposition of this landowner, which was being taken by the outside lawyer representing our company. We came armed with aerial photography of the property covering a period of about 25 years. The photos clearly show that her alleged lake had alternated between a muddy bog and a dried-out lake bed for at least the past quarter century, long before my employer even existed as a company. We also brought a lawsuit that she had filed about 18 years earlier against a nearby sand and gravel producer, alleging that their operations had drained the lake at the same time. He started by putting the photos in front of her one by one, beginning with the most recent and working backward, asking her about each one. By around the 12th or 13th photo, she became visibly panicked and started to get choked up. At that point, we pulled out the copy of the lawsuit she and her ex-husband had filed against the sand and gravel company. She broke down sobbing. She knew the jig was up and that she had been called out on her fabrication. There was never any big, beautiful lake. And even if there had been, she had already claimed someone else was responsible for ruining it. There was no plausible way she could continue to claim it was our fault. Her attorney immediately called for a break. They left the room. About 10 minutes later, her attorney came back into the room without her. He apologized, said he did not know when he filed the suit that she was lying or had previously filed a suit alleging the same thing, which we believed. He informed us that they would be moving to dismiss their claims the next day. Story 16. Child custody case. I'm representing the mom against the dad. The dad is representing himself. His big moment comes when he gets to cross-examine his ex on the record, in front of not only the court, but also his oafish pals. Except he has no idea what the rules of evidence are. During cross-examination, I object to every query he poses to the mom on the stand. My every objection is upheld by the judge. The guy actually breaks down crying in the well, frustrated at being denied this confrontation he's probably spent years dreaming about. Eventually, he abandons the examination altogether without posing a single question that my client had to answer on the record. My client got physical custody of their daughter, and I got bailiffs to escort us out of the courtroom, since the pawnage was so infuriating to some. Story 17. My dad's story. He was defending a client who had been arrested for robbing a store. The client swore up and down that he was innocent, that they had arrested the wrong guy and would not plead or accept a deal. He was black, and the police are obviously racist, so my dad thought it was fully possible that the police had just picked up the first black guy they saw and tried to pin it on him. Furthermore, the client was so insistent on his alibi and innocence that my dad fully believed him. When it came time to appear in court and enter a plea, he stood before the judge, who asked, "How do you plead?" Instead of pleading not guilty, he responded, "You mean how we robbed the store?" Story 18. When I was doing workers' comp defense, I had a guy who filed a bogus back claim after he got fired for being high and drunk at a construction job. With a quick Google search, I found all kinds of interesting things about him. He's a headbanging, aggressive, mosh pit fighting metal band singer. He's been longboarding and surfing all summer with no problem while on state disability, and he even had appearance on TV. In his deposition, he claimed everything hurt. He couldn't do anything, couldn't skate, couldn't surf, could barely walk, and had never had any drugs or alcohol problems. After setting him up, I pulled out a stack of his Facebook posts and pictures, and his eyes went wide. I told him it was time to stop lying. He admitted he skates, surfs, and goes into mosh pits once in a while, but insisted he was definitely injured on the job, and definitely fired for the injury and not for drugs or alcohol. Then I pulled up his TV show video on my laptop. It was one of the intervention shows, where his family and bandmates staged an intervention for his drug and alcohol abuse. He went white. His lawyer, already ticked off, yelled, "You were on a stupid TV show for this?" We took a break. He settled for $500, and his attorney stormed out. Story 19. Not me, but a coworker. Our client was an employee of a trucking company. The contractual agreement stated that the employer had to base the employee's pay on data from the truck's computer. And after that, the employer could add any corrections he saw fit. The employer provided a statement on how the pay was calculated. The employee then had 3 months to object to the calculation. If he didn't, the statement stood and wasn't easily disputed anymore. Our client claimed his salary was calculated incorrectly. Yet he couldn't prove he had objected. Our client said he did, and the employer said he didn't. Tough luck for our client, as it was basically a losing case. Then came the closing statements. The employee had the second to last word and said, "Although I cannot prove it, know that I am telling the truth and I did object." It was then the employer's turn to speak. To the surprise of all present, he said, and I'm paraphrasing, "I'm so sick and tired of seeing this employee and his constant and incessant whining about his payslip." Our client won. Story 20. I'm not a lawyer, but this happened to me last year. College town landlords can be super shady because they figure, not always incorrectly of course, that students are naive, poor, and unwilling to kick up a fuss to stand up for themselves. Our landlord emailed my roommates and me, informing us that the house we were renting had been sold and we needed to move out within the next 2 weeks. Now, there are a number of reasons why this isn't allowed, so I sought legal aid through my grad school. The lawyers looked up public records for the address of the house and discovered that our quote-unquote landlord was not, in fact, even the owner of the place and had been fraudulently charging rent the entire time. He had also declared bankruptcy last year and was currently being sued by 2 separate banks. I honestly expected to hear a rim shot following that discovery. It was a bizarre situation. We didn't move out of the house and stopped contact with him. Story 22. Years ago, I represented an alien in deportation proceedings. This was before DHS existed and INS was still around. After the first master preliminary hearing, I determined that my client was, in fact, a U.S. citizen. My recollection was that my client derived citizenship through a parent. At the next master hearing, I denied all charges of deportability and requested the case be terminated on the grounds that my client was a U.S. citizen. After submitting the pleadings to the court, the judge and the attorney for INS demanded evidence supporting my argument. Their attitude was so condescending and rude that I could not help but thoroughly enjoy opening my file and pulling out a brand new, sparkling United States passport. The courtroom was packed with other immigrants waiting for their cases to be called. As I held up the passport in view of the judge and opposing counsel, the courtroom went quiet. I informed the judge that neither he nor INS had jurisdiction over my client's liberty. The judge, temporarily emasculated, mumbled that he needed to see the passport. Moments later, proceedings were terminated, and my client walked out of the court with a big, cursing sound-like smile on his face. That was immensely satisfying. Another case involved a client coming to my office asking if there was some way he could become legal. He had been living in the U.S. for 10 years after sneaking across the Mexican border. Since he had no work permit, he had difficulty finding employment and was desperate to fix the situation. After going through his immigration and family history, I told him that I believed he was a U.S. citizen. To prove it, we requested a U.S. passport. A couple of weeks later, his passport application was approved. We then applied for a certificate of citizenship, which was also approved. The client couldn't believe he had spent 10 years of his life living as an illegal alien, when all along, he had been a U.S. citizen his entire life. Story 23. One of my close friends from law school went on to work with a small but very prestigious litigation firm. It was the kind of place where everyone worked 80-plus hours a week, drove expensive cars, and wore suits. On the other hand, I practiced estate planning, tended to wear jeans, and drove the car I had in college. I had closed down my solo practice since I was moving for my husband's job, and my friend hired me part-time to help train new law clerks on how to use legal software. It was a mix of glorified IT work and combined with babysitting law students. I mostly took the job as a favor to her since she was juggling multiple cases at the moment, and it gave me something to do for the 2 months until the move. To say the least, I was not going to run out and buy a bunch of suits for the position, so I continued my jeans look. About 3 weeks in, I was in the elevator and was joined by 2 men. One was clearly a lawyer, while the other was his client. The client asked the lawyer, "Do we need to tell them about the deleted emails and backup server?" The lawyer responded, "No, whatever you do, don't mention it. Lie if you have to, but don't mention it at all." We all got off the same floor and they walked into one of the meeting rooms. I went into my friend's office and told her to ask them about the deleted emails and the backup server. Apparently, the deposition was epic. The client cracked like an egg the second it was asked and spilled everything. Story 24. I work in family law. A client insisted that the employee his wife claimed was their family assistant was actually his wife's personal assistant. He maintained that he had nothing to do with her and all of her payroll should be allocated to his wife. Opposing attorneys showed up with an email from the client to the family assistant saying, "In future dinners, when broccoli is served, I require a higher floret to stem ratio." The payroll ended up being allocated to the community, and we consistently joke about florets. Story 25. I had a trial where a woman claimed she tripped in a store because of an obstacle. We had video footage showing that her shoe's heel broke. During her testimony, she stated that her heel had broken when she tripped over the obstacle. Under cross-examination, I asked her what type of shoe she was wearing on the day in question before showing the video clip. She said she was wearing shoes with heels and, funny though, she was wearing them again that day. I asked her to step out the witness box so the judge could see what they looked like, thinking this was a great move. As she stepped out of the witness box, her heel immediately snapped. They settled during the lunch adjournment. Story 26. My uncle, who is a civil lawyer, once told me this story. He was in court representing someone in a civil lawsuit. The defense brought in an expert on a certain topic that was a point of interest in the trial. The expert provided testimony that supported the defense's argument. During a recess, my uncle was waiting in a hallway and had a gut feeling that something was fishy. By chance, he looked at the top of a nearby trash can and saw a check statement addressed to the expert from the defense along with the instructions for what to say. When he returned to the courtroom, he called the expert back to the stand and questioned if he had been honest in his testimony. The expert affirmed that he was. Then my uncle pulled out the check statements and instructions. The expert and the defense team lowered their heads in shame. Story 27. My first prosecution case involved a man whose pit bull jumped a fence and attacked his neighbor's dog. The pit bull had locked its jaws around the victim's dog's neck, and the neighbor came out with a police baton to beat the pit bull until it released its grip. The dog control arrived later, but the offending pit bull had disappeared and was picked up later. We had the owner of the victim's dog as a witness, but he was quite drugged out and not the best witness in court. During the trial, the defendant's brother testified in his defense, claiming the dog wasn't even present that day because it was with him across town. Then the defendant himself took the stand and repeated the same story, becoming emotional about his dog, emphasizing its harmlessness and how much he loved it. He accused his neighbor of lying due to a vendetta against him. When I stood up to the cross-examine, I acknowledged his love for his dog and remarked that it must have angered him to see someone beating it with a baton. He agreed, saying he was real mad. I sat down immediately. His lawyer sighed deeply behind me, and the judge suddenly looked alert. The case was over. The defendant tried to backtrack, saying he meant if he was there, he would have been mad, but it was just too late. Story 28. The client in this case was the mother of 2 children, seeking a change to custody arrangements with the father from a previous hearing. The mother was struggling a little, but was doing her best to raise the kids. The father was a deadbeat. The guardian ad litem for non-lawyers, that's the court-appointed attorney who appears on behalf of the children in a case like this, compiled his report and essentially sided with the mother. However, he recommended that both parties take a drug test. Neither party objected, and the judge called social services to the courtroom. About a half hour into the hearing, the mother and father were called out to take the drug test, and the court recessed briefly. When the judge returned to the bench, she read the test results aloud. The mother tested negative for every substance that was screened for, she said. The father tested positive for cocaine. It was pretty much a downhill for the father after that. Cocaine isn't detectable in urine tests for very long at all, so either this guy did coke very recently or he was a habitual user. He basically admitted that the drug use but tried to argue over the specifics, made a bunch of outlandish claims regarding the mother, and got into a shouting match to the guardian ad litem. Needless to say, the court decided to adjust the custody agreement in favor of the mother. Story 29. I am a defense attorney who was having problems with the prosecutor's office not producing documents in a timely manner, if they would do it at all. They would file paperwork claiming they had supplied what was required, but we weren't receiving the documents. So without informing anyone, I closed our courthouse mailbox where they kept verifying that they had delivered the documents. 3 weeks later, on a Tuesday, in a very full courtroom, I was in a hotly contested hearing when I informed the judge that the required paperwork had never been supplied. The prosecutor then launched into a rant about how she had personally supplied the documents. I asked her how she had done so, and she confidently stated that she had placed them in my courthouse mailbox herself. I pressed on her when she had done this, and she claimed it was the previous Friday. I theatrically searched through my files and asked her again if she had personally delivered them just 4 days before the hearing. She responded indignantly, accusing me of wasting everyone's time, especially the judge's. That's when I turned to the judge, looked him squarely in the eyes, and said, "Your Honor, I'd like to ask you to call downstairs and verify with your staff that I closed my courthouse mailbox more than 3 weeks ago." The prosecutor's expression turned priceless, but the judge's was even better. As I turned to return to my seat at counsel table, the entire room was as silent as the grave. I won the hearing. Story 30. In landlord-tenant court in NYC, I represented the landlord in a no-lease holdover case where the tenant doesn't have a lease, so we can proceed with eviction. The tenant appeared with an attorney and presented a lease allegedly signed by the prior owner, covering 6 years, starting 1 year before my client became the owner. If true, my case would be dismissed because such evictions can't proceed if there's an existing lease. We conferred with the judge. The tenant's attorney exuded confidence, thinking he had the upper hand. The proposed settlement was dismissive to him. He smugly told the judge the story. The judge turned to me and remarked, "Counsel, this does not look good for you." The tenant's attorney smirked. I quickly retrieved the case file and found the deed. It was an estate sale, and both prior owners had been deceased for 5 years. It was impossible for them to have issued a lease to the tenant. I showed the opposing counsel the death certificates. The life drained from his face. The judge turned to him and said, "That's checkmate, counsel. I advise you discuss with your client the possibility of moving out within a short period, or I refer to this to the DA." It's rare to experience such a TV moment in everyday court proceedings. It was immensely satisfying. Story 31. Several years ago, I recounted this story, but it seems relevant again today. My brother is a divorce attorney, and his most memorable case involved representing a man in custody battle who was accused of horrific child abuse. The allegations were graphic, supported by detailed depositions from the young children against their father. Things looked grim. Then my brother noticed something peculiar in the deposition transcripts conducted by social workers under oath. At the end of one child's deposition was a question: "Did I hit my marks?" My brother, who had briefly pursued acting in Hollywood after high school, before opting for law, a very different form of acting, pondered how young children would be familiar with such acting terminology. During discovery, he subpoenaed the wife's personal checking account records and discovered payments for acting lessons. Armed with this new information, he deposed a highly suspicious acting coach. The coach, clearly rattled, quickly produced DVDs of practice interrogations, showing hours of coaching where the children were instructed on exactly what fabricated statements to make about their father. My brother said, Perry Mason moment, in over 20 years of practicing law, Dad got sole custody of the kids. Story 32. I'm not a lawyer, but I lived with a guy in our early 20s. He worked one of those furniture rental places for people without money, where he often repossessed furniture. In his spare time, he was an avid skateboarder. He severely injured his back on the job, and they were contesting paying his medical bills and settling the case. During one of his mediation sessions, they revealed they had hired a private investigator to follow him. They showed him pictures of someone at a skate park, supposedly him, skating when he was supposed to be recovering at home. They asked him to verify if it was him. He denied it. These individuals had somehow missed the fact that he had a twin brother who also skateboarded. Eventually, they settled for what I considered a very low amount of $70,000. He suffered from back pain for years, which led to weight gain and ongoing suffering. In his 30s, he finally underwent back surgery and regretted not doing it 10 years earlier. He said the surgery completely alleviated his pain. Story 33. I was prosecuting a traffic ticket and concluded my opening statement with something along the lines of, by the end of the day, you'll agree that the officer caught the defendant going 65 in a 50. The defendant, representing himself, stood up and said, while he may have clocked me going 65 in a 50, the judge immediately halted the trial, dismissed the jury, and remarked, you just confessed, so are we changing your plea to no contest or what? Note, Texas has a state constitutional right to a jury trial for nearly any offense. Story 34. Not so much of a gotcha as the defendant giving themselves up. When I worked in insurance defense, I handled a fraud case where a man reported his Rolex as stolen. He insisted it was taken while he was at a hotel, but couldn't provide any proof of his stay there, raising suspicions. We went through the entire process and finally reached depositions. During the deposition, he was sworn in and eventually admitted that he wasn't at a hotel at all, but rather with his mistress, and had left the Rolex at her house. His wife noticed he didn't have it on, prompting him to concoct the story of it being stolen. This man decided to hire an attorney and go through this whole circus just to prevent his wife from finding out about his affair. Needless to say, the claim was denied. Story 35. On the last day of a medical malpractice trial, the partner on our litigation team explained, this morning the judge dismissed our core argument and cut the legs off our case. We're dead in the water. The only thing we had left was to get the doctor to admit he didn't follow procedure and thus admit malpractice. Our senior litigator stood up like a grandpa and walked to the middle of the courtroom in a manner of a grandpa. He began to ask the doctor grandpa-like questions about the medical field. Slowly, he would say things like, I read in this book right here in my hand, that this is what your job is. Is that correct? And your colleague, an expert in the field, says this about the procedure. Is that correct? Eventually, the doctor started to get frustrated with the grandpa and began explaining things condescendingly, asserting that grandpa wasn't qualified to ask him about the medical field on his job. Grandpa then asked him about the procedure, surprisingly spry and witty, unnoticed by the doctor. So then you did this next? Wrong procedure. No, because blah, 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 the doctor retorted. And then after you learned that, you did this next? Correct procedure. No, stunned silence in the room. Wait, you mean after you learned about blank, you didn't do XYZ before proceeding? No, the doctor looked confused as to what just happened. It was totally like a few good men. Story 37. I've only been practicing for 6 months, so this might not be the greatest story, but here's the shortened version. A man claimed that his live-in girlfriend of multiple decades was just a licensee. In less than a week, Village Housing Court waits for no man. I prepared the trial to protest this, starting by contesting the service of process and then objecting the idea that she was merely a licensee. During that time, I contacted my client's bank and obtained a copy of a mortgage on the property that my client had co-signed with the man. I also extensively interviewed my client to create a timeline of events, identifying several factual errors in the man's original filing, such as shaving off 10 years from the duration she had lived with him. I submitted my findings, including the mortgage copy, to the court the day before the trial. At the court hearing, fully prepared for trial, the judge unexpectedly announced that he was dismissing the proceedings. It wasn't due to the flawed service or factual errors in the filing, but because the mortgage suggested my client had equity in the house. According to the judge, this meant the dispute had to be handled in a court of equity, not in Village Housing Court. I had anticipated a trial but managed to have the entire case dismissed without one because I secured the crucial part of evidence by simply requesting it from the bank. Note, a licensee is someone who resides on your property because you allow them to, out of goodwill. If you've ever had a friend stay on your couch for a few days because they were evicted, that friend was a licensee. They are distinct from a tenant or subtenant who pays rent to live there. Story 38. A few years ago, just a few days before Christmas, I received a call. This was about a situation where firefighters had performed maintenance on a hydrant and negligently left it locked down, causing water to spew into the air after they departed. This water flooded the yard and subsequently the house of these unfortunate homeowners. The city admitted fault and agreed to reimburse the homeowners after work is done. The homeowners attempted to file a claim with their homeowners insurance, and their company reviewed the claim. Despite the city admitting fault and being liable, the insurance company declined coverage. According to them, they would cover the damage only if the water had hit the roof of the home first and then caused flooding. Since the water hit the yard first and then flooded, they deemed it surface water and stated it wasn't covered under the policy. I was floored. All they needed to do was take care of the house and get reimbursed. Instead, they were playing games with these poor people. When it comes down to it, insurance is nothing more than a contract. Contracts have legal terms of art, and it just so happens surface water is one such term that basically means naturally occurring water, which this clearly wasn't. After providing the Black's Law Dictionary definition of the term, the State Water Resources Department definition, and finding it in a state statute, they decided to take a closer look. Only after I made it clear that their options were to own up immediately and get reimbursed, or deny and face a pursuit for 3 times the damages for the best bad faith claim I'd ever seen did they relent. Unfortunately, I only got a 5-star review out of it and the positive feeling of helping during the holidays. Story 39. Client was the town drunk. One day, an officer saw him staggering down the street carrying a bottle of vodka and arrested him for public intoxication, but no breath test was conducted. I discovered that the client had another issue. He had another PI that was set to be dismissed if he went 6 months with no other offenses. The police officer arrived with the bagged evidence, the vodka. He testified that my client wobbled down the street and he had a bottle of booze. I asked if he had tested him to confirm that he was drunk. He said no. I asked, so what you describe as a wobbly gait and this bottle is what caused you to think that he was drunk? He answered yes. I asked if he had noticed anything odd about the bottle. He said no. I then pointed out, so you failed to notice that the bottle appears to be full and the seal on the lid isn't broken? He examined the bottle and conceded the point. The judge had a big laugh and dismissed the charge. The prosecutor then argued that the client should be punished for the other offense. I pointed out that the court's docket sheet indicated it was to be dismissed if he went 6 months with no other offenses, and it was a few weeks past 6 months. Since the only charge filed against him had just been dismissed, so should the prior one. The judge had a second good laugh and dismissed it. Story 40. Just had to deal with this case just about a year ago. Purchased an old rundown house on the terms that it would get rezoned to be a commercial lot. In the closing, along with that term of rezoning, it was agreed that the bank that had the deed to the house would pay the property tax in the spring. We got the property, demolished the house, and put up a big old shed. 2.5 years passed. One day, out of the blue, the garage doors were barred shut and the key wouldn't unlock the door. I figured we had been struck by lightning or something, and one of the neighbors shut and barred the garage doors. And our lock was always kind of, janky. We replaced the locks, unbarred the doors, and went on with our business. The next day we went back, same thing happened. So we picked the lock and replaced them again. Finally, the next day there was a piece of paper saying that this property had been bought with a tax deed, and we had 10 days to get everything out or was to be the property of the new owner. Outraged and confused, I called the number on the sign and yelled at him, threatening to call the police if he wouldn't stop harassing us. He went on to explain that he had bought the tax deed because we didn't pay taxes on it. Stupid. We had taxes and land assessment sent to our home address and paid everything we had ever gotten on time and in full. It got dug up that the bank never paid the tax that was agreed upon in closing, and the city never gave us a warning about it. They sent us over 2 years of taxes and other things for that property to our home address, but failed to send the message with, "Hey, we are selling your shed." So the city was trying to screw us and almost got away with it because we didn't have a mailbox there. It was obviously maintained. I cut the grass every week, yet the city claimed it was abandoned. Easy enough case. Had to sue the city and the bank and settle for the property back and lawyer fees. Moral of the story, put a mailbox on all your properties. Story 41. In a dispute with an employer, I was declared unfit to work due to disability that I have had for my age. They replied to say that due to that, I wouldn't be paid and included the phrase, due to your quote-unquote disability at the start. They normally paid full pay, so this was treating someone differently because of their disability status, which is completely illegal here, and which changes damages for wrongful termination from a year of pay and unlimited amount. My representative just sent them a letter pointing out that they just admitted discrimination, and they started talking settlements straight away. Disappointingly, I settled fairly quickly with them to get a reference for a new job, which I never asked for. They could have essentially taken them for much more, and they deserved it, really. Story 42. As a paralegal, I recently dealt with a case where the plaintiff claimed to have slipped and fallen in our client's store, resulting in a serious injury that allegedly left her unable to walk due to back pain. As part of our routine investigation, we obtained surveillance video from the store. The footage clearly showed her walking down the aisle at the supposed time of the incident, not slipping or showing any signs of distress. Instead, she walked casually, glanced around, then suddenly began limping severely and headed to the front of the store to report her fall. During her deposition, conducted under oath but outside the courtroom, we questioned her extensively about the incident, how she fell, where it happened, what she fell on, and her immediate physical reactions such as pain or numbness. She described the incident in detail, emphasizing the severity of her injuries and how they had impacted her life, claiming she could no longer work. When our attorney announced that he wanted to show her the surveillance video, her own attorney quickly pulled her aside for a private discussion. 20 minutes later, they returned and informed us they were dismissing the case. Story 43. Although I would like to attribute this outcome to my superior legal skills, it's somewhat hard to do so. The plaintiff, who was quite unpleasant, claimed he had been assaulted by security guards and suffered a traumatic brain injury. He was seeking damages exceeding $2 million, and his below-average attorney had incurred significant fees and costs, especially with experts to support the TBI claim and the high damages sought. During the plaintiff's deposition, I subtly inquired about any trips or vacations he had taken after the alleged incident. He admitted to going on a church trip for Bible study. When I asked him about the activities on this trip, he essentially responded that he attended Bible study and mostly rested in his hotel room due to lingering effects of the TBI. I proceeded to ask him a comprehensive list of questions about activities like A, B, C, etc. during this trip. He denied participating in any such activities and reiterated his claim of being unable to engage in physical activities. I also questioned him about his ability to do various tasks, including driving. While he admitted he could drive, he mentioned being frequently distracted and having slower reflexes than before, expressing concerns about his driving ability. Prior to the deposition, I conducted some basic social media searches on the plaintiff and discovered just about a year after the incident, he had gone on a vacation where he engaged in jet skiing and other activities. The plaintiff had even posted vacation photos on his social media account. Armed with this information, I asked him about his activities to set up the questions. Then I sprung the jet skiing photos on him during the deposition. Furthermore, the plaintiff had posted photos after the incident showing his speedometer while driving at speeds exceeding 100 miles per hour. Needless to say, the case was resolved shortly thereafter. What a moron. Story 44. Gotta love employment law. A client of ours fired an individual who wouldn't cut his hair. It was long, gross, and mangled. He filed an EEOC complaint, a required precursor to employment litigation, claiming that he didn't cut his hair for religious purposes, and thus suffered discrimination on that basis. After some digging, his barber had no problem producing receipts for all of this guy's visits in the last 2 years. Claim closed. Story 45. So I'm handling this divorce case against this crazy opposing party husband. He's flooding me with crazy emotions, making ridiculous arguments. Getting a restraining order against me for putting a knife to my wife's throat violates my Second Amendment rights, and threatening me via text and voicemail. The only reason I'm still on the case at this point is because he's doing it deliberately to try to scare lawyers off the case, and I refuse to give him this satisfaction. Anyway, we finally get to the contested divorce hearing, and he is calling witnesses left and right to talk about how my client's lying about everything, and how he's an amazing person, of course. We break for lunch, and he goes and drags his non-marital son, who's taking midterms during his senior year of high school at that time, out of school to come testify. I object, but the judge doesn't want to be overturned on appeal, so he lets the kid talk. The husband then proceeds to question him about the last time he traveled for work and let the kid stay home alone. Not a big deal. The son's 18 with a job and a car. And how he gave him 5 chores to do. Even though the trip got unexpectedly extended for an extra week, he came home and the kid had only done 4 out of the 5 chores, forgetting to fold laundry. The husband then asked what he did to discipline, and the kid goes, "You told me since I didn't fold my laundry and thus disrespected your orders, I could leave your house. And since I didn't have any clothes hung up or folded, I couldn't wear any outside." The husband smiled and said, "Did you learn your lesson?" To which the son replied, "Yes, sir." And then he ended his questioning. I pause and look at co-counsel, who as stunned as I am. My client starts to say something to me, and I shush her and had the following exchange. Me. "So just to be clear," kid's name, "you were kicked out of the house in February without clothes because you failed to fold your laundry?" Kid. "Yes, sir." Me. "But you did all the other chores?" Kid. "Yes, sir." Me. "And you didn't throw any wild parties or get any tickets or anything, right?" Kid. "No, sir, I just forgot because I was doing homework and picked up extra shifts at Walmart so I could buy food." Me. "Because your dad's trip got extended and he didn't leave you enough money for food." Kid. "Yes, sir, though I did buy pizza one night for a study group I was in, so that may have contributed to it." Me. Looks at co-counsel. "No further questions, Your Honor." Needless to say, my client got sole legal custody and placement. Story 46. I work at a law firm that helps elderly and disabled individuals obtain benefits from the government. One of our clients was a World War II veteran, and in almost a decade of representing her, we made constant tiny steps and barely got anywhere. This woman was barely alive, and her family was struggling financially. It took ages, but we finally got a motion for oral argument approved by the court. 2 days later, the government lawyer calls with a decent settlement. We negotiate with him, and although we didn't secure what was truly believed she deserved, we got a lot more than we thought we could realistically get for her. Turns out, the higher-ups weren't too keen on being on live or recorded broadcast, explaining why the government didn't want to give this World War II veteran benefits. Story 47. I was a young lawyer with a case where the opposing party, plaintiff, claimed all his medical bills, including a shoulder surgery, were due to the accident. He provided me with the names of his legitimate doctors, so I obtained and reviewed all the medical records. As luck would have it, I found in those records the name of an additional doctor he hadn't disclosed. I obtained those records and discovered just how extensively he was doctor shopping for pain pills. The floodgates of proof of his pill shopping opened wide. Cut to the doctor's testimony, where his doctor was called to testify that this man's injuries were all legitimate and due to the wreck. So I started showing him records one by one of this guy jumping to a new doctor almost every other day. Meanwhile, I was handing copies to opposing counsel, who had never looked at the records and had no clue about them. He was visibly upset and started throwing the documents directly on the floor, having a full-on temper tantrum. This was from an experienced lawyer who had just been outsmarted by a young girl. We won with a complete defense verdict, which was significant because almost any plaintiff in his situation would have at least gotten his initial ER bill covered. To this day, it remains my greatest Perry Mason moment ever. Story 48. Assault case. During opening, the state claimed one of their witnesses was an over-the-road trucker in California, which is why they couldn't make it. I thought about objecting, but then decided I could hammer them with it more effectively in closing. My client started writing me notes that he's in town and just moved out of his victim's house. They had broken up. Sure enough, my client's wife called up this waitress and found out he's in town. And not only that, he's literally staying a half block away from the police station. I informed the state that their witness had likely perjured herself and suggested she should consider dropping the case. She said no. So I called my client's wife as a witness. She explained he's not in California, and we presented a video of her talking to him the evening before. Despite this, the state called their victim back to insist he's out of town. I used this opportunity to have her authenticate my video, confirm who was in it, and verify the location. But she claimed it was old. The jury acquitted my guy in under 5 minutes. Story 49. Got involved in a case a year and a half after a ridiculous judgment of over $1 million was entered against my folks. They know nothing about it until their farm was literally about to be sold to satisfy the judgment. I was skeptical because of due process and notice requirements. Anyways, I looked at the record and requested a transcript of this so-called default hearing. No evidence whatsoever was presented, and the petition was not verified by the plaintiff. How we even got here is beyond me. I filed my motion to set aside with the attached transcript, in which nothing but a discussion of filing and some blanks occurred. At the hearing, I basically said my motion speaks for itself. The other attorney went on and on about how evidence was presented, dragged his elderly client in to testify on the stand, blah, blah, blah. I just let him keep going. Evidently, he hadn't really read what I filed. When he was done, I simply pointed out to the judge that if he would read the attached transcript, none of that even remotely happened. That shut the attorney up real quick, and now I kind of understand how he might have gotten this so-called default judgment without my clients knowing about it. Opposing counsel lied flat out to a judge when it was clear that he had messed up just by reviewing the record and documents filed with the court. Story 50. Here in Brazil, I had a client arrested for drug dealing based on an anonymous statement made by telephone. This statement, illegally based on operation with phone call interceptions, included my client's phone calls. Every time she talked to the other suspects, they said things like, "Will you grab the thing? I will deliver that today. When will you bring it?" They never explicitly mentioned the object of their conversations. Without any drug apprehension whatsoever, my client and the other suspects were arrested, remaining in jail for 8 months. The court rejected my corpus petition, even with the lack of evidence. So, in the hearing, after I had instructed my client very carefully, the judge started questioning her, and then the ultimate question was asked. What were you talking about on the phone calls that you called that, it, thing? She could have said chocolate, toilet paper, whatever. But no, she said, I was talking about weed. Case closed. How can someone be so stupid? Story 51. I had a client who was out of the country, but his brother-in-law had been recklessly driving using my client's license for a month. As a result, my client's license was ultimately suspended. We cleared up the tickets in 3 out of 4 towns. However, in a busy city precinct, he showed up and they arrested him. It was a Saturday, and I submitted all the proof to the ADA, who didn't review it. Monday morning at arraignment, I convinced the judge to hold a hearing so we could resolve it and my client could move on with his life. The police station was across the street, and I knew the cop was on desk duty Monday morning. The judge's intern ran over and I got her. She was clearly annoyed to come to court. Since she was being difficult, I insisted she be sworn in. I asked her if my client was the person she pulled over and ticketed, and she insisted he was. Then I showed that he was out of the country and that the 3 other towns dismissed everything. She turned beet red, and I could tell she wanted to jump across the table and take a swing. She then argued with the DA that he should call to confirm my story. The DA ignored her, and then she came over to me, calling up unprofessional in an open court packed with 100 people. I simply said I wasn't the one who just lied under oath and that I was willing to let that go because I knew the DA and judge weren't going to pursue her for breaking the law. She walked out of the courthouse. As she left, all I said was, "Next time, you could be nicer." Story 52. In a murder case, a witness testified that my client had confessed to him while they were incarcerated together in the local jail. The witness had finished serving his time by the date of the trial. The prosecutor made sure to point out that the witness had nothing to gain from testifying since he did not have any current charges or sentences that they were seeking to have reduced in exchange for his testimony. During the cross-examination, the witness reiterated that he was testifying because it was the right thing to do and not because he was getting any benefit. Then I played a phone call that the witness had made on the recorded jail phone line a year earlier. In the call, the witness was telling his significant other that it looked much better when you testified when you didn't have any pending charges, because that was like a credit card that you could use when you got in trouble in the future. Following that, I played several other calls where the witness discussed how to lie in other people's cases in order to get out of jail. The case worked out pretty well for my client after that. Story 53. I was the lawyer's client defendant. My disk drive failed. I have repair receipts. About 5 months before the plaintiff brought suit, so I had lost many email records of my interactions with the plaintiff. The plaintiff worked at an out-of-state firm and often emailed me from the firm's email server. During discovery, among a long list of questions, my lawyer required all emails to or from me from the plaintiff's personal and law firm server. the latter to be delivered by the plaintiff's law firm IT person. Of course, the plaintiff's management would not allow their system to be combed through for personal emails and incur the risk of accidentally sending confidential client information. Hence, the plaintiff could not respond to a reasonable request for evidence, and the judge issued a summary judgment to dismiss the lawsuit. I doubt that the plaintiff had any emails that would go against me, but my broken hard drive ended the case. Story 54. I represented a bank in a jury trial against borrowers who stopped paying back their line of credit. We had gone through discovery trying to settle. Opposing counsel told me that they were insane and would not settle. In depositions and on the stand, they generally came across as very unsophisticated, uneducated, offbeat people, which is considered normal in our town. But after spending hours talking to them, it became clear that they just had no intention of paying their loan and presented a handful of contradicting assertions to explain why. It was already paid. The bank paid themselves. There never was a loan, and there was a loan, but the original lender had gone out of business, so the loan had evaporated into some mysterious void, etc. At trial, it seemed like the jury was buying the idea that they were confused about where to make their payments due to the bank being evil and intentionally trying to mislead them just to foreclose. Then she said the loan had been paid. I had her testimony from deposition where I had asked her who paid off her loan. In deposition, she said she had. In trial, she looked me dead in the eye and said, "My man." I assumed that she meant her husband, but I asked her to clarify and she said, "Obama," and then started laughing. I said, "You're saying President Barack Obama paid off your mortgage?" And she said yes. I asked her to explain and she said to be paid off a whole bunch of mortgages. I asked if she had brought proof with her and she nodded and then dropped it. When the jury returned a verdict from my client, she cried. The actually crazy part of the whole thing is that after all that, we went to sale and a third party bid more than the bank was owed. So they ended up with the difference, about $20,000. Story 55. Client was sued by an ex who claimed he didn't pay back a loan she gave him for the business. My client said she invested in the business. I had some documents showing the business was listed at her house, but not enough in my opinion. So I subpoenaed the ex for everything she had on the business. She gave me really horrible copies I could hardly make out. So I sent a letter demanding she send me better copies, or I would move the judge to dismiss her claim. Stupid. At trial, I moved for dismissal on the grounds that she didn't properly respond to my subpoena. She brought all the documents to court, and the judge, not wanting to dismiss, gave me the choice to either continue the case or take a few minutes to look at the documents outside. She represented herself, and judges tend to cut pro se parties a lot of slack. I chose to look at the docs again. After testifying on her own behalf, insisting that the money was a loan, I pulled out a bank document, asking why her home address was for the business. The ex's answer was simple. Her ex, my client, lived with her. Then I pointed out the end of the bank document where the word partner was printed right under her signature. Story 56. It was my first time defending a municipality at a county-level residential tax appeal hearing, so we're not talking anything serious. Anyways, the real estate appraiser's report cited a decrease in property value due to a close proximity to a dive bar, among other things, and included pictures taken from the property's backyard. I got the appraiser to admit he used a zoom lens to fill the frame, aka make the bar seem closer. The taxpayer still got a reduction based on comparable sales, but I felt cool. Story 57. I work as in-house counsel at Compliance in Pharma. We received an allegation of an investigator having coerced an employee, let's call him Juan, into incriminating himself and admitting to offering sponsorship to a physician, which is prohibited in our part of the continent. The person alleging, let's call her Maria, did so in Juan's behalf. First slip up. I know the investigator well, and he is straight by the book and would never do anything like that. But for the sake of investigation, you always have to put aside what you know about anyone. The other detail is that I knew the questioning of Juan was as a witness to Maria's misconduct. She was making the allegation on his behalf to call the results of the investigation into question and save herself. When we spoke to the employee that allegedly suffered the coercion, Juan, he was infuriated that Maria would complain on his behalf, knew nothing about it, and insisted that he could complain for himself if he was ever coerced, and that everything he said was the truth. He also knew that all to be true because we swept his WhatsApp and saw the messages from Maria to Juan. Of course, when confronted with Juan's report that he wasn't coerced, she tried to backtrack in a big way and even retire the claims. But it was too late. She hadn't counted on Juan's honesty. The The gotcha wasn't too dramatic, but it was essentially knowing that Maria was trying to game the system, thinking she was smart or somehow manipulating the results, not knowing how connected compliance tracking really is, and ended up looking even worse for doing so. Juan kept his job. Maria lost hers. Honesty pays. This is the end of the video. Thanks for watching.